Hey there, my friends! Welcome to those of you watching us for the first time, and to those of you already sharing this journey with the Academy, thank you so much for joining me again. Here we're exploring international law. The two playlists mentioned above are the paths that we have took so far, and I am here to take it further by drawing the law alive. We are talking about subjects of international law, which you can revisit the created videos about that in my playlist above. In today's video, we will talk about transnational corporations. Ready your curiosity, and let's begin this new chapter together. Transnational corporations, or TNCs, are enterprises that operate across national borders, managing production, services, or trade in multiple countries simultaneously. In international law, they are recognized not as full-fledged subjects with treaty-making power like states, but as influential actors whose activities affect international economic, social, and environmental norms. Transnational corporations shape international law in ways that are subtle, yet profoundly powerful. Their economic weight alone allows them to influence negotiations between states, affect the drafting of treaties, and sometimes even shape the priorities of international organizations. By lobbying governments and intergovernmental bodies, they can push for rules that facilitate investment, trade, or regulatory flexibility, effectively becoming a silent architect of norms. Their partnerships with organizations like UN Trade and Development or the Commission on Transnational Corporations allow them to contribute expertise, data, and policy recommendations, which are often incorporated into international guidelines. So, in essence, even without full legal personality, these corporations leave a tangible imprint on international law, from trade and investment frameworks to labor, environmental, and human rights standards, illustrating how economic power translates into normative influence on the global stage. Transnational corporations can, in certain situations, be treated as subjects of international law, even though they are not sovereign entities. One key exception occurs when they are involved in international dispute settlement mechanisms, such as investment arbitration under frameworks like ICSID, or when a state consents to their participation in specific legal processes. In these cases, the corporation's rights and obligations are recognized by international law, allowing them to bring claims, defend themselves, or be held accountable across borders. This recognition is contingent and limited, arising from the consent of states, international treaties, or specific contractual agreements, rather than inherent sovereignty. It highlights how international law can adapt to functional realities, granting legal personality to private actors when necessary to ensure accountability, investment protection, or dispute resolution. Transnational corporations can also interact with the United Nations in ways similar to NGOs. The UN established the Commission on Transnational Corporations, composed of 48 member states, to study and monitor the activities of these corporations. The Commission analyzes their functional, economic, and behavioral impact, identifying areas where corporate actions may cause social, environmental, or regulatory challenges. One of its key tools is the development and promotion of a collection of codes of conduct, which set standards for responsible corporate behavior at the international level. Through these mechanisms, the UN seeks to guide transnational corporations toward practices that align with international law, sustainable development, and the broader goals of the international community, while still respecting the voluntary nature of compliance. Despite their significant influence, transnational corporations face important challenges and limitations under international law. They are primarily regulated by the domestic laws of the states in which they operate, meaning their global activities are constantly subject to differing legal regimes. Their lack of full international legal personality also limits their direct accountability at the international level, making enforcement of obligations dependent on state cooperation. Moreover, TNCs face criticism and scrutiny from civil society, NGOs, and international organizations when their practices conflict with human rights, environmental standards, or labor laws. Disputes often arise over tax obligations, intellectual property rights, and corporate governance. highlighting the tension between their economic power and the legal frameworks meant to regulate them. These limitations show that while TNCs are influential actors, they operate within a complex network of legal, political, and social constraints that shape and sometimes restrain their role in international law. And that's it, my friends. Now you know what it means for TNCs to be subjects of international law. See you next time!